press matter.
ಇದು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಡ್ತೀವಿ.
ಅದರಲ್ಲಿ ಅವರು ಪ್ರೆಸ್ ಮಾಡ್ಲತ್ತಿದ್ದಾರೆ. ಸಬ್ಸ್ಟೆನ್ಸಸ್ ಅಲೌನ್ಸ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ಇಲ್ಲಿ ಅವ್ರು ಪ್ರೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್
ಇಲ್ರಿ, ಇದ್ರ ರಿಟ್ ನಲ್ಲಿ ಅಲೋ ಆಗಿದೆ ಅವ್ರದ್ದು ರಿಟ್. ಸಬ್ಸ್ಟೆನ್ಸ್ ಅಲೌನ್ಸ್ ಅವ್ರು ಪ್ರೆಸ್ ಮಾಡ್ಲತ್ತಾರೆ ನಮ್ಗೆ ಕೊಡು ಅಂತ.
ಸಬ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲೌನ್ಸ್ ಆಯ್ತು ನಾಳೆ.
One matter, my lord, regular first appeal.
LAC appeal, my lord. I'll file memo for withdrawal tomorrow, my lord.
Withdrawal tomorrow.
My lord,
send tomorrow.
MSA fresh matter, my lord, appeal service insurance company. Claimant they offered EPA.
Tomorrow.
my lord, the Central Administrative Tribunal, my lord, has allowed my application, and my lord, the matter is remitted back, my lord, to the appellate authority to reconsider. It's been 3 years, my lord, they are squatting on the file, my lord, and now a fresh list of promotion, my lord, is being issued, in which, my lord, people who are junior most to me are being, my lord, promoted.
Monday.
My lord, there's some urgency tomorrow, my lord.
Monday. But Monday.
List is issued, my lord, now, even, my lord, issuance of notice tomorrow would, my lord, suffice probably.
Right.
Please, my lord.
One regular first appeal.
Yes, Deshmukh.
My lord, just recalling the date appeal is the can.
ಅಲ್ಲ ಆಯ್ತು, ಏನ್ ಹೇಳಿ.
Tomorrow it may.
ಅರ್ಜೆನ್ಸಿ ಏನು ಇಲ್ಲ ಅಂದ್ರೆ ಸೋಮವಾರ ಮಾಡಿ.
Urgency, please.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
Because the writ petition is dismissed, my lord.
This
Writ petition is dismissed. I have come for the appeal in this.
ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ? ವಾಟ್ ಇಸ್ ದ ಮ್ಯಾಟರ್?
Service matter.
Service matter. You are for the workman, huh?
No, he is a policeman. Police department.
Right.
This tomorrow, please.
Mine is also recalling. Lordship had directed to pose this matter after complaint. So I had complied, my lord. It is pending for recalling. Writ appeal, fresh matter. Recalling, just recall. Wait.
One regular first appeal, my lords, wherein land, the plot of the petitioner as well as the respond number, petitioner was acquired, my lords, appellant was acquired. Thereby, my lords, illegal construction was done in the plot of the petition, appellant, my lords. Now the apportionment, my lords, only with a title value, the amount has been awarded to the appellant, my lords. And the respondents have been granted the entire construction of the house, my lords, value of the house, my lords, wherein in
tomorrow. Yes.
On RFA, tomorrow EP is coming before the execution court. There are urgency.
On writ appeal, lords, today at 12 noon, appellant is the Adhyaksha of the Gram Panchayat. Motion of no confidence was moved against him. That was challenged in a writ petition before the learned single judge on the ground that there was no 15 days clear notice to the appellant. Now that writ petition has been dismissed. Against that, lords, writ appeal is filed. Today at 1 o'clock, the...
Yes, please.
ನಾನು ಮಾಡಿಸ್ತೀನಿ by 12 o'clock.
Just find out telephonically.
And there is a caveat also. I shall also serve copy on the...
Just find out telephonically what the from the AC 15 days.
I have secured the document notice. Also, I am producing along with my application.
That is their document. Your document and instruction. You find out. Telephonically, you get instruction.
Please.
Advance copy. Page adjournment. Page number 8, number 37 to 43, 45 to 48.
Serial number 38, my lord.
Yes.
But serial number 38, my lord, your lordship is directed the, my lord, this is my lord, Gunda Act matter, my lord. Your lordship is directed the, my lord, petitioner to give the representation. But they give the representation to the superintendent of the jail. That is forwarded to the, my lord, government. But he has to give the directly to the, my lord, Home Secretary. Now, my lord, in turn, we send it to the Home Secretary. But Home Secretary is that...
let it come. No, let it come. Let it come. Now, what is the use if 12 months goes away?
That's why, my lord, your lordship is directed to the give the representation.
We will have to decide it otherwise. We only made a suggestion that... No, that's okay. Then we'll decide it. What is the purpose of having it for 12 months?
That is true, my lord. The Home Secretary... Information is not received from the Home Secretary, my lord. That is the...
Let us see when it comes.
Number 9,
please.
Number 44 to 48.
Serial number 47. But I am per respondent number 2.
Mood it, isn't it? You inform him. Just inform him.
Please.
If he says Monday, it's okay.
Please.
You just report to the court officer.
I will inform.
Please.
10, 49 to 56. Page number 11, till number 57. Pronouncement of order, serial number 1, SS Mamada.
For the petitioner.
Order, the writ petition is allowed. The order of detention dated 21/9/2024 passed by respondent number 2, bearing number RBMUG Gunda Act 98/2023-24, subsequent confirmation order dated 5/11/2024, bearing number HD 508/2024 passed by respondent number 1 stands quashed. Consequently, the respondents are directed to set the detainee at liberty forthwith. The registry is hereby directed to communicate the order to the respondents as well as the jail authority to release the detainee forthwith if his requirement is not needed in any other cases. No order as to costs.
Orders matter, serial number 2, Hema Kulkarni.
Lord, in this case, I have received the letter from the CEO saying that they are going to accommodate both of them to the job. Lord, but in respect of respondent number 4 is not ready, along with the memo I'll produce, my Lord. Respondent number 4 is not yet given any documents, my Lord. We have informed him. Last time, Lordship had asked respondent number 4 to inquire and.
Just read it,
My Lord, sorry, just morning they have given the copy, my Lord. In that, as the.
Just read it.
Please, my Lord. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ರಿಟ್ ಅಪೀಲ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಬಿಟ್ವೀನ್ ಶಾಣಬಸಪ್ಪ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಸಂಬಂಧಿಸಿದಂತೆ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಲಯವು ನಾಗೂರು ಗ್ರಾಮ ಪಂಚಾಯತ್
On the mic. Mic on.
ಮೈಕ್ ಸದರಿ ಪತ್ರ ಪರಿಶೀಲಿಸಿದಾಗ ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿ ನಾಗೂರುರವರು ಶ್ರೀ ಶರಣಬಸಪ್ಪ ತಂದೆ ಮುರುಗಪ್ಪರವರನ್ನು ನಾಗೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ತೃಪ್ತಿಕರವಾದ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಯಿಂದ ಅನುಮೋದನೆ ಸಹ ಪಡೆದಿರುತ್ತಾರೆ. ಇವರು ಕ್ಲರ್ಕ್ ಕಮ್ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಹುದ್ದೆಗೆ ಮುಂದುವರಿಸಿಕೊಂಡು ಹೋಗಲು ಸಹ ಮತ್ತು ಹೊಂದಿರುವಂತಹ ಒಂದು ಮುಂದುವರೆದು ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುದ್ದಿಗೇರವರು ಯಾವುದೇ ದಾಖಲಾತಿಗಳು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ. ದೂರವಾಣಿ ಮೂಲಕ ಮಾತನಾಡಿದಾಗ ನನ್ನ ಹತ್ತಿರ ಯಾವ ದಾಖಲಾತಿಗಳು ಇರುವುದಿಲ್ಲವೆಂದು ಹೇಳಿರುತ್ತಾರೆ. ಮಾನವತೆಯ ಹಿತದೃಷ್ಟಿಯಿಂದ ಅವರು ಯಾವುದಾದರೂ ಕರ್ತವ್ಯಕ್ಕೆ ನಿಯೋಜಿಸಲು ಕೋರಿ ಪತ್ರ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ ಶ್ರೀ ಶರಣಬಸಪ್ಪ ತಂದೆ ಮುರುಗಪ್ಪರವರು ಗ್ರಾಮ ಪಂಚಾಯತ್ನಲ್ಲಿ ನಿಯಮಾನುಸಾರ ಡಾಟಾ ಎಂಟ್ರಿ ಆಪರೇಟರ್ ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಂಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ನಾಗೂರ್ ಪಿಡಿಒ ರವರು ಪತ್ರದ ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಸಲ್ಲಿಸಿದೆ.
Now that other respondent
number 4, my lord,
was granted relief in this before the single judge.
Yes, my lord.
Isn't it?
Yes, my lord.
He was directed to take him.
My lord, actually what happened, my lord, in the year 2009 itself, he had left the job.
Correct. So what
Later
is the
on,
operative portion now?
My lord, operative portion. My lord, in page 16, in that view of the matter, the order passed by respondent number 3 was thoroughly justified and therefore no interference is required as writ petition is dismissed.
So what is that order? Let's have a look at that.
My lord, we had
page.
The order of dismissal, my lord, it is at, I'll just.
Page number 6.
Annexure D. Annexure D is at page number 38, my lord. relevant page, relevant at 39. ಈ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಮಾಡಿದ ವಿಚಾರಣೆ ಹಾಗೂ ಕಾರ್ಯನಿರ್ವಾಹಕ ಅಧಿಕಾರಿ ತಾಲೂಕು ಪಂಚಾಯತಿ ಕಲಬುರಗಿರವರು ಪತ್ರದ ಆಧಾರದ ಮೇಲೆ ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುದ್ದಿಗೆಯವರನ್ನು ನಿಯಮ ಬಾಹಿರವಾಗಿ ತೆಗೆದು ಹಾಕಿ ಶ್ರೀ ಶರಣಬಸಪ್ಪ ತಂದೆ ಮುರುಗಪ್ಪ ಬಿರಾದರ್ ಇವರನ್ನು ನೇಮಕ ಮಾಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆದುದರಿಂದ ಹಾಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಶ್ರೀ ಶರಣಬಸಪ್ಪ ತಂದೆ ಮುರುಗಪ್ಪ ಬಿರಾದರ್ ಇವರನ್ನು ತೆಗೆದು ಹಾಕಿ ಶ್ರೀ ರಾಜ್ಕುಮಾರ್ ತಂದೆ ಬಸವರಾಜ್ ಗುದ್ದಿಗೆ ಇವರನ್ನು ಕಂಪ್ಯೂಟರ್ ಆಪರೇಟರ್ ಎಂದು ನೇಮಕ ಮಾಡಿ ಕರ್ತವ್ಯ ಹಾಜರುಪಡಿಸಿಕೊಳ್ಳಲು ಆದೇಶ ಮಾಡಲಾಗಿದೆ.
So now the Rajkumar was appointed.
Initially appointed.
Annexure?
My lord, his appointment letter is not there. There is no any
They have not
document.
produced it.
No, my lord, they are not.
No, correct. But by virtue of the order of the single judge,
Yes,
Rajkumar's appointment was upheld.
Yes, my lord.
And this Sharanabasappa was set aside.
Set aside, my lord.
Now by virtue of this offer,
Yes, my lord.
Sharanabasappa has got a job,
Yes, he'll be continued.
isn't it?
Yes, my
His
lord.
writ petition was rejected.
Yes, my lord.
So technically Rajkumar's continuance technically is on record.
Yes, my lord.
So he cannot be aggrieved.
Yes, my lord.
So now insofar as the appellant, in light of this memo filed, their grievance stands redressed.
Yes, my lord.
So we can dispose it off.
Yes, with
Taking note that they have no grievance in light of this order.
Yes, my lord.
And we leave it at that.
Yes, my lord. In respect of Rajkumar, we have already said we are going to provide him an alternative job.
No, correct. Now that was always the position.
Yes, my lord.
Now
Yes.
he is not an aggrieved party.
Yes, my lord.
So the appeal will be disposed of
Yes.
in light of the memo document filed. So you withdraw it in light of that as a grievance stand redressed. Will
But it needs to be set aside. I think. The order is setting aside my appointment. So that needs to be set aside.
In view of the memo filed,
Memo, the order of the learned single judge needs to be set aside. Only then my dismissal order will be set aside.
okay, that we'll say. In light of the memo accommodating you into employment, the question question of adjudication will not arise.
Please.
Question of adjudication will not arise as the grievance that by virtue of the single judge's order they have been removed is now reconsidered by them by virtue of the memo filed.
my lord, till date, the appellant has not been removed. He is continuing in view of interim orders, my lord. He is, the appellant has never been removed. He is still continuing in view of the interim orders, my lord. She is still working.
Could. We'll say in light of this.
Please, my lord.
The stand, grievance of the appellant stands addressed. While making it clear, the order of the single judge, now grievance as regards the order of single judge is
already
addressed by the stand of the employer.
And I'm already in job and by virtue of the interim order, I have already in service. Never I have been terminated.
Interim order is
Interim order.
My lords, whether they are provided me other, what kind of the job that
You are always there. By virtue of the order of the single judge, your continuance was recognized by the court. Now in the memo, they say they want you to give some documents. So they have not disturbed you. Nobody has disturbed you.
in the same panchayat, my lord?
Huh?
In the same panchayat, my lord?
Not same panchayat, my lord. He will be continued in nearby panchayat, which is convenient to him.
There is an
Because from 2009 he is not working. From the year 2009 he is not working, my lord. Only when the matters were, when the postings were given that any contractor also will be regularized.
And now you take benefit. Now anyhow,
Yes, sir.
appeal is by them.
Yes,
So in
ma'am.
their appeal, we can't give you any much more relief.
Yes.
However, we'll record this memo.
Yes, my
In
lord.
which they have asked you to give your records.
May I take my client instruction, my lord? He is come before.
ಇದಾರಾ?
ಬಂದಿದೆ.
Pass over.
Please.
8 ವರ್ಷ ಆದ್ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ. 9.
Yes. After 9 years only.
Pass
when-
over, pass over. Now you file a memo, however you want. We'll take note of it.
In view of the memo,
Huh?
my grievance is already redressed.
Correct.
So in view of the memo, now only they need to.
Okay.
Number 3.
So you file a memo saying that in light of their memo, matter may be disposed of.
Please.
Please. Yes.
3. Santosh A.
Yeah, petitioner, my lord. In this case, N.S. Deshpande is no more, my lord. Already memo for retirement. In this case, petitioner number 5, 6, 7 already filed. My lord, petition number 1, 2, 3, 4 court notice maybe.
No, but does it survive for consideration? What is the main matter?
My lord, senior is
What is
no
the
more,
main-
my lord. That's
Huh?
why. Senior is no more Deshpande.
Correct.
That's why my already memo for retirement, my lord. Others petitioners court notice, my lord. 1 to 4, my lord. Petitioners. 5, 6, 7 already filed, my lord. Wakalat. Siddharudu B. Pujari file ಮಾಡಿದ್ದಾರೆ. ಮಾಡಿದ್ದಾರೆ. ಇಲ್ಲ ಒಳಗಡೆ ಇದೆ ನೋಡಿ.
Then counsel for petitioner files a memo for retirement. Full stop. Taking note that the case on hand is a petition by the workmen.
Yes, ma'am.
Accordingly, it would be appropriate to issue court notice to
Petition number 1 to 4, my lord. 1, 2, 3, 4, my lord.
petitioners number 1 to 4. What
4.
about 5 to?
5, 6, 7 already filed Siddharudu B. Pujari, my lord.
Huh?
Siddharudu B. Pujari already 5, 6, 7, my lord.
ಹಾಕಿದಾರ
ಹಾಕಿದ್ದಾರೆ, my lord.
ಎಲ್ಲಿದೆ
ಇಲ್ಲ ಆಲ್ರೆಡಿ ಇದೆ.
ಒಟ್ಟಲ್ಲಿ ಹಾಕಿದಾರ ಚೆಕ್ ಮಾಡಿ ಎಷ್ಟು ಕನ್ವೀನಿಯಂಟ್ ಇದೆ ತೋರಿಸಿ ಚೆಕ್ ಮಾಡಿ ಕನ್ವೀನಿಯಂಟ್ ಇದೆ office to show the name of learned counsel
Siddharudu B. Pujari.
for petitioners
5, 6, 7, my lord. Yes, ma'am.
yes huh?
Number 4, Santosh Kumar Biradar.
May I permitted to take a hand summons. My lordship, boss. Notice is not served. I am permitted to take a hand summons in this case because respondent has remained the ex parte before the family court.
You will take out hand summons.
Yes, please, yes, my lordship.
The appellant submits. He may be permitted to take out notice by way of hand summons.
Yes.
List after 2 weeks.
Please, yes, my lordship.
Emergent notice and notice through. You want notice regular not required. Insufficient ಅಂತ ಇದೆ ಅಲ್ವಾ ಇನ್ನೊಂದ್ಸತಿ ತಗೊಳ್ಳಿ. Emergent notice along with the
Hand summons.
hand summons.
Please.
Emergent notice is also ordered to the respondent, the appellant to furnish a complete address. Yes.
Number 5, additional SPP, Vishal.
Next week, my lords, reference matter.
Friends,
Next
my lords,
week.
I was asked to place overtime chart I had prepared. I was asking for suspension of sentence.
Yes. If I can find it.
I just for in there is a direction from the court, so I had prepared it.
Put it.
See, 4 people have supported out of various eyewitnesses, and my lords,
Yes, we'll see. We'll see.
let there be direction to prepare the paper book also.
Counsel for the appellant in criminal appeal number 200176 of 2024.
150.
File overtax chart of each accused. The same is placed on record. Please disappear in the second week of March.
Let there be direction to prepare paper book also, because your lordship has already expressed an opinion to take a final look.
Is directed to prepare the paper book.
Much of-
Immediately.
Yes.
I'm grateful.
Number 6, Sanket Appaji.
Lordship,
Appear
this
for
matter,
the respondent, my lord.
we are filing the affidavit, Your Lordship. On last date of hearing, Your Lordship had directed us to file the affidavit. It is a case where Your Lordship, Bullock Cart Way has been expanded and a road has been formed in the lands of the petitioners, Your Lordship.
Now first you take us the refresh our memory. Refresh our memory.
Your Lordship,
What is the direction?
directions to the learners.
Page. 13. Single judge's direction first.
Page number 4, Your Lordship.
Single judge's direction.
Page number 4, Your Lordship.
Operative portion used.
Last para, Your Lordship. A perusal of the writ papers would reveal that the petitioner has, Your Lordship, a representation was.
Perusal of the writ papers
would reveal that the petitioner had made a representation on 10/2/2022 vide annexure C. Hence, the court deems it proper to direct the fourth respondent, the Executive Engineer Public Works Department, PWD Office, Kalaburagi, to consider the representation submitted by the petitioner and act in accordance with law within 3 months from the date of receipt of.
What was your representation?
Lordship, our representation was that road.
Page.
That is not part of this.
Okay, what was it to what effect?
We say that government is laying the road. If government wants to lay the road, let them acquire the road, and particular acquisition proceedings may be initiated, and let them lay the road, Your Lordship. Your Lordship, they have already laid the road now, Your Lordship, and Your Lordship, they have filed an affidavit. The respondent have filed an affidavit, Your Lordship. If I may take Your Lordship's attention to the page number 8 of the affidavit. Your Lordship, this is a notification on the basis of which this particular road has been formed in the petitioner's land, Your Lordship. The heading says, Your Lordship, if I may read. ಗ್ರಾಮೀಣ ರಸ್ತೆಯಿಂದ ಜಿಲ್ಲಾ ಮುಖ್ಯ ರಸ್ತೆಯನ್ನಾಗಿ ಮೇಲ್ದರ್ಜೆಗೇರಿಸಿದ ರಸ್ತೆಗಳ ವಿವರ.
Now it is in this context that you gave the representation.
No, Your Lordship, we said that representations
in this context.
Please, Lordship,
because they are upgrading the road.
They are upgrading the road. Let them acquire the land and lay the road, Your Lordship.
Serial number?
Which is at serial number 29, Your Lordship.
29.
That is the next page, page number 9. It is at serial number 29. Kadganchi to Bodan, Your Lordship. MRD is the major district road, Your Lordship. MRD represents major district road. So, Your Lordship, in the last column, Your Lordship, there is 55. That is the kilometers, Your Lordship. There is a length of the roads in kilometers. That is not the width of the road, Your Lordship. Now, Your Lordship, they themselves have filed an affidavit which is at page number 2, Your Lordship. Page number 2 of the very same. Page number 2, Your Lordship.
Page 4.
Page 2.
Which paragraph?
Para number 7, Your Lordship. Para 7 and 8 are relevant paragraphs, Your Lordship, which they say that it was 3.7. Please, Lordship. It is relevant to submit. It is relevant to submitted that after handing over the said road to our department, we carried the work in existing road that is 3.75. Existing road, which they say 3.75 meters. The copy of the necessary records for improvement of the existing width road. The copy of the said acknowledgement here is so and so, which is annexure 3 R3. It is relevant to submit that after collecting all the records, we issued the letter intimating that our department has not acquired the land of the complainant, but we improved and developed the existing 3.75. Your Lordship may kindly mark existing 3.75 meters only. Your Lordship, but this is a MRD, Your Lordship, major district road, Your Lordship. The major district road, Your Lordship, it is width is 5.5 meters. That is standard value. I have filed along with my affidavit, Your Lordship.
Take us to your affidavit.
Affidavit, that is the internet on the search, Your Lordship. It says that standard width of the major district roads is 5.5 meters for a single lane, Your Lordship. 5.5, which is at page number 3, I guess. Major district roads. The standard width for major district roads is 5.5 meters for a single lane and 9 meters for the 2-lane road. Your Lordship, here they have laid a single lane road, Your Lordship. So that is 5.5 meters. Even Your Lordship directed us to calculate or measure the width of the road, Your Lordship, which we have measured, Your Lordship, which is at page number 4. And even today in the morning also we have measured, Your Lordship. It is coming to the 5.5 meters, Your Lordship. 5.5 meters. Your Lordship, a false affidavit has been filed with the government, Your Lordship.
5.5 meters.
Please, Lordship.
ಈ ಫೋಟೋಗ್ರಾಫ್ ಅಲ್ಲಿ ಗೊತ್ತಾಗುತ್ತಾ? ಎಲ್ಲಿಂದ ಎಲ್ಲಿಗೆ ಅಂತ. Now in the affidavit, what you have stated?
We have stated the same thing, Your Worship, that there was a government order saying the submissions made by me, Your Worship, are being put forth in the affidavit. The heading itself says that, Your Worship, the details of the village roads which are upgraded to the major district road. Now, the major district road, that is standard width is 5.5 meters, Your Worship.
What is this photograph you have produced?
That is to show that we have measured, Your Worship.
May I request your lordship make submission, my lord?
Explaining this details. Yes, yes. Now, just one minute.
Please,
Just one. Mallikarjun, just one.
please,
Now,
please, my lord.
can you give us a copy of what representation you have made? We'll pass over.
Right now, I don't have, Your Worship. I don't have right now. I'll just see, Your Worship. Kindly pass over, Worship. 2:30.
Over.
2:30, please.
Otherwise, you take the record in your writ.
Please,
take a copy of that photo. You can ask the court officer, ಅಥವಾ record ತರ್ಸೋದು, ಅದನ್ನ writ petition papers ತರ್ಸಿ. In that you have stated, isn't it?
We stated that if they want to acquire the road and lay the road, if they want to lay the road, they can acquire the land and give the compensation and then.
Yes, Mallikarjun.
Please, my lord, here, my lord, in other matters, my lord, your lordship is directed us to not get the measurement, my lord, through ADLR. In this matter also, my lord, your lordship directed the ADLR, my lord, to submit the report. Clear picture will be come before lordship, my lord. If it is, my lord, we used the extra road, my lord, definitely we'll request the acquire the land, my lord, definitely. That is better, my lord, that is.
Your Lordship, if ADLR is appointed, it is again from the government side.
Yes. We'll say in your presence.
He has to file. He has to file affidavit also.
Yes, filed affidavit. Yes, filed
Yes, my
affidavit.
lord, definitely.
So we'll say in your presence.
Please, Lordship.
The petitioner had filed a writ petition 201634 of 22 asserting that petitioner was the owner and in possession of survey number 71/2 measuring 4 acres 1 gunta situated at Tadtegnur village, Kalaburagi Taluk and district, and that the authorities had planned to lay a road without acquisition. Accordingly, representation was made out. The learned single judge disposed of the representation, directing the executive engineer public works department to consider the representation and act in accordance with law. Full stop. Next. During the pendency of the present proceedings, affidavit has been filed by the executive engineer PWD with a specific assertion that the land of the petitioner is not utilized beyond 3.75 meters and the road has been laid only in an extent of 3.75 meters. The counsel for the complainant has filed a rejoinder in which it is specifically averred that the road widening was in the context of upgradation of the existing road to a major district road.
Please.
Which is to 5.5 meters.
Please.
Full stop. It is submitted that in terms of the standards applicable to major district road. The width of a single lane road would be 5.5 meters. Reliance is placed on the notification. Reliance is placed on the notification produced along with the affidavit by the executive engineer PWD published in the Gazette on 24th September 2020. And it is pointed out that even as per the say of the authority, the road referred to at serial number 29 refers to upgradation to a major district road. And if that were to be so, the say of the executive engineer PWD that they are laying a road only in 3.75 meters width is contrary to the standards of a major district road. Full stop. It is further asserted that the present measurement of the existing road is 5.5 meters.
Please, Lordship.
And accordingly, the affidavit by the executive engineer PWD is contrary to records. Full stop. Prima facie, we find substance in the assertion of the petitioner. Full stop. In order to demonstrate that the consideration is not a mechanical consideration, the respondent executive engineer
PW department.
PWD who has to file a fresh affidavit with report of the ADLR with respect to the width of the road running through the complainant's property while ADLR is conducting measurement in order for the same to be furnished before this court, the complainant to be notified and measurement by the ADLR to be made in his presence. Full stop. For said affidavit and report of ADLR, which would throw light on the nature of consideration, relist the matter on. Yes, Mallikarjun.
Please, my lord, your second week of March, my lord.
Good. But you warn your officials saying that, see, if you are, that they have to do it correctly. Let them not try to cover up. If mistake is done,
Your Lordship, let the ADLR file a report on my presence. Maybe in that.
we have ordered that.
Please.
We have ordered that. Let it be done in his presence.
Yes, my lord, we will issue notice to him also. We will ask the ADLR to issue notice. One word, your lordship, not direct the ADLR to visit the spot and make the survey, my lord. One word, your lordship, direct to the.
Needless to state, the ADLR is to personally visit the spot and measurement be done in his presence as also in the presence of the complainant.
Please.
Yes, copy of the order to be furnished to government advocate.
A date for measurement may kindly be fixed.
They will fix it. They
Please,
will fix it.
Please. Grateful, Lordship.
Yes.
Number 7, Basavakirana Chia.
Please, my lord.
I am for the respondent
complainant.
1 to 6 minutes.
In this case, my lord, I have just been brought to my notice that not only they have committed a contempt, but they have filed a false affidavit, patently false affidavit with incomplete documents. In fact, my lord, my contention is.
What was the
interim order?
What was the direction?
Interim order was granted, restraining the accused herein from the interim order is on page number 15 of my contempt petition. The operative portion is on 16. The respondent 3 to 8 are restrained from in any manner appointing any new personnel or taking new loan and or selling any of the property of the society till next date of hearing. In this case, my lord, at the time of passing the interim order, the accused were put on notice in para 1 of the said order. Para 1, Sri Amrishas Roja, Learned Counsel, filed caveat for respondent 3 and 5, accepts notice for respondent 4 and 6 to 17 also. So they are represented by counsel. It's not an ex parte order. So in presence of the counsel, it was passed. However, my lord, the very next day, in spite of knowing the interim order, they move a application seeking to appoint certain new staff to the society. It's a educational society. They want to appoint several new staff members. That is found in Annexure B of my writ petition, is reference number 4.
Yes.
ಅಧ್ಯಕ್ಷರು ಕಾರ್ಯದರ್ಶಿಗಳು ವೀರಶೈವ ವಿದ್ಯಾವರ್ಧಕ ಸಂಸ್ಥೆ ತಾಳಿಕೋಟಿ ರವರ ಪತ್ರ ದಿನಾಂಕ 14/7/2023. And in the first paragraph also of the said communication, ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖ 4 ವೀರಶೈವ ವಿದ್ಯಾವರ್ಧಕ ಸಂಸ್ಥೆ ತಾಳಿಕೋಟಿ ಮುದ್ದೇಬೇಳ ಜಿಲ್ಲಾ ವಿಜಯಪುರ ಇವರು ಸಂಘದಡಿಯಲ್ಲಿ ನಡೆಯುತ್ತಿದ್ದ 2 ಅನುದಾನಿತ ಪ್ರೌಢಶಾಲೆಗಳಾದ SK ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜ್ ಮತ್ತು ಪ್ರೌಢಶಾಲೆ ವಿಭಾಗ ತಾಳಿಕೋಟಿ, SKK VM GSM ಬಾಲಕಿಯರ ಪ್ರೌಢಶಾಲೆ ತಾಳಿಕೋಟಿ ತಾಲೂಕು ಮುದ್ದೇಬೇಳ ಇವರ ಅನುದಾನಿತ ಪ್ರೌಢ ಶಾಲೆಗಳಿಗೆ ದಿನಾಂಕ 31/12/2015 ಅವಧಿಯಲ್ಲಿ ಖಾಲಿಯಾದ ಬೋಧಕ ಸಹ ಶಿಕ್ಷಕ ವೃಂದದ ಹುದ್ದೆಗಳನ್ನು ತುಂಬಿಕೊಳ್ಳಲು ಉಲ್ಲೇಖವನ್ನು ಇಲಾಖೆ ಅನುಮತಿ ದೊರೆತಿರುತ್ತದೆ. So it's clear that it's a letter written by this thing. I applied for a copy of the letter as per Annexure C. As per Annexure D, I get a reply that it cannot be given to me. ನೀಡಲು ಬರುವುದಿಲ್ಲ ಅಂತ ಕೊಟ್ಟರು under RTI. Thereafter, I filed this contempt petition. This honorable court was pleased to issue notice, and accordingly, my lord, on 12/2/2025, an affidavit was filed. At the outset, I may submit that it's not a apology affidavit, though there is one line paragraph that they have utmost high regards for the order and of this court. They have taken up contentions on merits. First, they contend that it is an interim order, therefore I cannot be held guilty of contempt. That is the first contention. I'll come to that.
No, with that we don't have to enter. Now, go to the present affidavit of 24th February. Now
I'll just come. This is important.
No, correct. Now I'm saying, now they're saying that we are not going to take any steps.
I'll just 2 minutes of the court's time. I'll clearly demonstrate on face of it that it's a false affidavit. Kindly, my lords, para 6 in the affidavit dated 12/2. This is in fact the main affidavit. There they claim that the reference number 4 in Annexure B.
Read.
Please. The complainant made a complaint in the captioned complaint contemplating that subsequent to interim order dated 13/9/2023, there was a intra-department communication made by the block education officer Muddebea to Deputy Director Vijaypura, wherein in reference 4, it is stated that President Secretary Veervashaiva Vidyavardhak Sangha Talikoti wrote a letter to the block education officer on 14/7/2023. That is next day of the interim order dated 13/7/23. It is submitted the reference 4 in the intra-department communication dated 13/9/2023 is an endorsement issued by the block education officer and not the request made by Secretary President of the Vidyavardhak Sangha Talikoti. Therefore, allegation of the complainant is incorrect. And respond number 1 to 6, accused number 1 to 6, never ever overreached the order passed, that is interim order passed in writ petition number so and so. The endorsement issued by block education officer in respect of the request letter made by Secretary Veershaiva Vidyavardhak Sangh dated 12/7/2023. Copies of application and endorsement is produced as Annexure R1A, B and C. So this is the crux. He says that it 14/7/2023 is only an endorsement, not his letter. And he produces the endorsement at Annexure R1A on page number 6. Typed copy is on page number 7. They claim that by wrongly it is mentioned as our letter. It is not our letter, it's an endorsement. I respectfully submit, my lords, that we have obtained a copy of the said endorsement. That endorsement, according to our information, my lord, it has been issued on the back of the very letter which we have complained. 14 on 14/7/2023 letter they have given. The BO, this is the letter. On reverse of it, he has put an endorsement. They produce only one side of the order endorsement. They don't produce the reverse side. Reverse side produce matter, they will be fully exposed.
So that has to be summoned.
Yes, my lord.
Kindly see page 8.
No,
In the same affidavit, my lords, page 8,
Okay,
Annexure
you
R1B, my lords, the very same letter I produced.
Page?
8, page 8, Annexure R1B, my lords, the very same letter is produced. And kindly see at the left side, my lords, the endorsement by the block education officer is on 12/7/2023. This is not first time, my lords. They are indulged in manipulating the records. There are cases against them.
This letter, my lord,
The very same letter is now the complainant is referring, my lords.
No,
R1B.
is that reference 4, is it?
Please. The very same letter now the complainant is referring.
Original reports.
The very same letter, my lords.
Very same letter, but date,
Very
my
same
lord,
letter.
they have kept it blank here. In my copy, they have put 14. This is the letter.
Very same letter, my lords. The
Yeah,
very
and
same. Nothing. The false affidavit is not filed, my lords. They are indulged in a manipulation of a records. There are criminal case against them, my lords, which pending before the criminal court. Now they don't want merits argued on the merits of the matter, my lords. They somehow, my lords.
Let them move the matter. We are ready on merits. Writ petition. In fact, if the order sheet is
The
produced,
letter itself contemplates, my lords. It was on 12. 14th was on endorsement.
No, now.
No false affidavit is filed, my lords. Next affidavit I filed saying that, my lords, undertaking we will not take any appointment till disposal of the writ
On
petition.
record, they're not going to do it.
pardon, my lord.
They placed on record, they're not going to take any action.
I would have understood, my lord, so that if they had contrite heart, if they had sought apology, sincere apology, then court, I would have also not much harped on the matter.
Correct, that is between us and him.
That is true, my lord. But still, being part of the institution.
The lordship aware, my lords, taking abundant precaution in every affidavit, we, my lords, seek apology. Then, my lords, without retracting that, my lords, we are allowed to put case on merits also.
My only grievance is this thing is,
the very same letter.
same letter, but that is, my lord, manipulated. If that record is produced,
No,
it will be in black and white. Allah.
There's no point in spending any further time. We find that.
Allah, first they commit a contempt, then they cover it up by filing false affidavit and manipulation of records.
Now they've come clean. There ends the matter. They're not going to take any further steps. It's against an interim order. The petition was filed seeking for initiation of proceedings for contempt in light of disobedience of the interim order dated 13/7/2023 in WP 201846 of 23. Interim order at annexure A. Interim order is produced at annexure A, in which there was a direction that the respondents were restrained from appointing any new personnel or taking new loan or selling any property of the society till the next date. The outside it must be noticed that the interim order was till the next date. It is the case of the complainant that in terms of annexure B dated 13/9/23, it comes out that in terms of reference number 4, steps were taken contrary to the interim order to fill up the post. Accordingly, it was submitted that there was willful disobedience of the order. The affidavit at the first instance was filed on 11/2/2025 and with along with the annexures. An affidavit is subsequently filed on 24/2/25, in which it is specifically covered at para 4 as follows. Taking note that the contempt is against the interim order, the governments of para 4 are taken note of, and it is found that in light of the said undertaking, the cause is made out.
One submission, my lord.
Yes.
Even in para 4, it is to be noted, interim order is dated 13/7/2023. In para 4,
Now they're saying they will not take any further steps.
they mention that after interim order dated 37/23. Interim order is dated 13/7.
By mistake, typing mistake.
And then another place, interim order dated 13/9/23.
Adu clerical mistake.
Affidavit.
File a memo.
So
Please, that course of the
that
day.
shows that they have violated, and after that, if action is not taken in such cases, my lord, brazen unconditional apology, I would have understood. I would have not pressed. Summon the file, let it be on record.
You file affidavit by tomorrow.
During the course of the day, I will file memo.
File
My
it.
lords. It's a clerical mistake.
Pass over. Okay, if you can file, you file it.
I will file memo. My lords.
Memo.
No, can you
To correct affidavit memo.
you file an affidavit? We can have it tomorrow and correct
In the kindly see, my lords, in the earlier affidavit also.
No, apology, forget dates. They appear to be a mismatch in the dates.
Clerical mistake. Then the first affidavit nodita. Para 7 ali.
Para
7 ali. First affidavit till para 7. Para 7. First affidavit. Pair. That apart, it is submitted in pursuance to the interim order dated 13/7/2023. There is no appointment made by the respondent 1 to 6 accused. Therefore, on this count also, the complainant cannot contend that 1 to 6 willfully disobeyed the impute order. For the we have taken a stand saying that, my lords, we did not made any appointments pursuant to the interim order.
Full stop. Along with annexures. Full stop. Para 7 of the said affidavit reads as follows. Full stop. Counsel for the respondent submits that they would be bound by such undertaking.
Please.
And no appointment would be made contrary to the interim order in force.
Please.
In light of the same, proceedings are dropped. Yes.
Okay.
Number 8, Mahantesh Patil.
Yes.
Mahantesh Patil.
This matter.
Correct, but you can't be so correct.
Lord, this matter, my lords, in respect of the person, the petitioner has suffered injuries in the by connecting, my lords, by coming into contact of the live electrical wire. Yesterday, your lordships have heard 2 days before.
Heard. No, correct, but we wanted a FIR investigation
Yes,
report.
Lord, it is, Lord, for the injured or, Lord, victim's family to, Lord, inform under 161, Lord, section of Electricity Act.
Correct, under Electricity Act, there is a provision, isn't it? In case of accidents, there must be an inspection.
Yes,
and report
ma'am.
filed by the electrical inspector.
Yes, Lord, it is, Lord, there is no such work going on, Lord. In fact, it is in.
What I'm saying, suppose there's an allegation, then immediately under some provision of the Electricity Act, the electrical inspector must file a report.
Yes, my lord. What had happened in this present case, my lord, in 2013, in 2011, notice is given to, my lord, all the residents to, my lord, vacate the premises wherever, my lord, under the high tension wire on their own, my lord, self-execution. And, my lord, they did not do, my lord, and continued. And this is how the incident happened. And they couldn't bring to the knowledge of our information to the, my lord, JESCA. This is how the electrical inspector also, my lord, could not carry out any, my lord, having no knowledge of, my lord, this incident occurred.
Not come out.
No, my lord,
Okay,
communication.
but after the FIR is filed, There must be some police investigation.
FIR also, my lord, we inquired, my lord, probably, my lord, it is closed, my lord. Even somebody told.
Okay, we'll adjourn it anyhow.
Please.
We passed an order.
In this
The
case,
directions passed in the order. Observations made in the order dated 24/2/2025 is to be taken note of.
one submission,
parties.
One submission is, in the year 2011, all the residents of the village lords have given the application to shift the line.
So we'll hear it, let us see, but once FIR is filed, closure report, etc., you get certified copy and place it on.
Please.
Let us have a look if something comes out from that. We'll know.
Much.
Yes.
Please.
Next.
Lord, may I make one submission apart from this matter? Lord, day before yesterday's matter, that order is not yet abused. May I request for that, Lord, announcement of results of Lord.
Yes.
Please.
Today it will be
Today,
released.
please. Much.
They are placing before us, after verification, you get the ground correct.
Lord, I'm sorry. Lord, stay granted earlier in this present matter. Please.
The interim order, yavrali.
Serial number 8.
Interim order earlier granted in 8.1.
Please.
Is continued till the next day.
Published.
Number 9, Ananture.
Paper.
Court mic is muted, my lord.
Let us see the direction.
Page number 13, my lord.
For how many months? How many months? How many months?
It is for 3.
How many months salary?
Salary, my lord, for the period 1/1/2022 to 17/4. So around
1.5 years.
15 months.
They have not paid you, is it?
Yes, my lord.
You have worked for that.
Yes, my lord.
No, but for government, why you are required to pass?
Without approval from the government, my lord, his work danta or contention ide. He has to take in permission from the government prior to.
Now he's been employed by the municipal corporation.
No, not directly employed by the municipal corporation, my lord. It is through agency.
Necessary stand to be taken positively by the next date. Relist the matter on.
12th of March.
On failure to take any stand, the R2 to be present through video conferencing on the next date.
Please.
Registry to share the link, video conference link, list the matter on 12th.
Great.
Till number 10, Arun Kumar Amaragundappa.
This is day before yesterday's matter. My lord, here the revised rate he has to pay. The complainant has already paid the entire cital value. Now, in view of the, my lord, enhanced compensation by the Supreme Court, my lord, the rates are revised. The revised rate we are seeking. Your lordship can make a word, my lord, to grant some time. Ad bekare time tagond kodli. But now the value of the site is nearly 1 crore now. Even the revised rate is also very lesser to the comparing the market.
What was the direction?
To collect, my lord, the balance cital value
Yes,
at the rate of 9% interest.
That is the direction.
Yes.
Yes, that direction at that time, my lord, the Supreme Court was not passed any orders. The LAC, SLPs were pending, civil appeals were pending. And thereafter, my lord, there was huge enhancement. This was, my lord, a rate fixed at the rate of 1,80,000 per acre we have purchased. On that basis, including development charges, that rate was fixed. And as per condition number 14 of the allotment letter, the rate of the site will be revised at any time because of the court orders and the for making of payment.
The Tengli, there is one difficulty from your side.
Please.
Without entering into the merits, Roman 2 says making payment of balance amount.
Yes, my lord.
Balance amount as aforesaid. So what is the balance amount?
Yes.
As on that, now the enhancement was done after the writ order.
Yes, my lord.
Writ appeal.
After that, when was the enhancement? That is in the balance they pointed out.
Yes, ma'am.
Huh?
Yes.
Subsequent to these.
In the February.
And they say they just refer, my lord, SLP is pending before the Honorable Supreme Court in the order. They are not specific, my lord.
ಈಗ ಹೇಳಕ್ಕಾಗಲ್ಲ ಎಷ್ಟು ಹೆಚ್ಚಾಗುತ್ತೆ ಅಂತ
ಅಲ್ಲ
ಹೇಳಕ್ಕಾಗಲ್ಲ
ಅವ್ರು ಯಾವಾಗ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು ಅವ್ರ SLP.
His argument is as on the date the writ was.
Yes, my lord. His argument is this is the rate I have paid and they have to execute. He is, my lord, speaking on the basis of that. But the condition number 14 of the allotment letter, ಅವ್ರು ರೆಡಿ ಇದಾರೆ.
Relist the matter.
ಅವ್ರು ಟೈಮ್ ಕೊಟ್ಟರೆ ರೆಡಿ ಇದಾರೆ ಸ್ವಾಮಿ ತುಂಬ್ತೀವಂತ.
ಇಲ್ಲ ನಾನು I sought, my lord, since he is ex-service man, already died, my lord, during the pendency of contempt, during the consideration period, my lord, before authorities.
Relist in second week of March.
Please.
Yes.
Number 11, Shivashankar H. Manu.
My lord, submission with regard to the translation copy, my lord, that may be dispensed. Submission with regard to other office objection are complied, my lord. With regard to only translation copy.
Office objection regarding furnishing of translated copies.
My lord, this matter is
in abeyance for the present.
Lord, this matter is pursuant to the Land Grabbing and Prohibition Act, my lord. And as per Annexure A, the special court has taken the cognizance against the petitioner. In the year 2008, the third respondent gave a complaint against the petitioner before the special court, saying that it is a encroachment of the petitioner property. Since 1960, I have produced, my lord, amended act, my lord. Annexure F is the copy, my lord. There is an amendment in the act, my lord.
Section 9.
ಅದರಲ್ಲಿ Section 2 ನಲ್ಲಿ jurisdiction ಬರಲ್ಲ ಅಂತ ನನ್ನ ಪಾಯಿಂಟ್ ಇದೆ, my lord. Section 2 is now amended, my lord. Section 2D1, my lord. Original act is, my lord, 2011. Now 2022 ದಲ್ಲಿ amendment ಆಗಿದೆ, my lord. It is a distance from Tikota Pattana Panchayat to the petitioner's land.
Once issue ಆಗಿದೆ.
Entirely, my lord.
Just one minute. What is the amendment?
Amendment Act, my lord, 2022, my lord, section 2 is amended, my lord.
We don't know it's prospective or retrospective.
I produced, my lord, copy.
We don't know if it's prospective or retrospective.
Yes, that is written in the act. I produced, my lord. It is respect.
Now,
Annexure F, my lord.
it applies only to land falling within 18 kilometers.
ಅಲ್ಲ ಅಲ್ಲಿ ಹೇಳ್ತಿದ್ದಾರೆ my lord, provided that excluding.
What is the point you're making?
My point is, my lord, in the act says, my lord, from town panchayat to the particular property, there must be within 3 kilometers. My case, my lord, I have given my case is more than 13 kilometers, my lord. There is no jurisdiction to the special court.
Now, where is your place? Which village?
Yes, my lord. My place is, my lord, the Torvi Tanda Cross is my place, my lord.
Huh?
Torvi Tanda Cross.
Torvi Tanda.
Yes, my lord.
That is how much distance?
My lord, Annexure F, the Right to Information Act I have applied, my lord. Annexure F, they have given regarding the distance. Annexure F, they have given the information.
Now, how many kilometers your Torvi
Yes,
Tanda?
13 kilometers. So, Tikota Town Panchayat to our place is 13 kilometers.
Go to page 21.
Please, my lord.
Go to page 21. 21.
21, my lord.
He says 1 kilometer.
Yeah, yeah.
That
ಏನಾಗಿದೆ, my lord?
No, no.
Tahsildar.
That report we don't know.
Yes, my lord.
That report you go before the authority and point out.
Allah, my lord. We have pointed, my lord.
No, you point out there before the court.
Torvi is just outskirts of the Vijaypura.
Not page number.
We don't know. Both of you know. Don't know. So we are saying whether it is 1 kilometer away as per the report referred to in page 21. You go to page 21. In the said report, it is stated survey number 11 is a distance of 1 kilometer from the Tikota Patan Panchayat. Now, whether it's 1 kilometer or 13 kilometers, let it be decided there.
Yeah,
right?
I have obtained the certified copy, my lord.
We can't do it in writ proceedings. You go there, it's factual. How can we look into facts in writ proceedings?
My lord, in the order, my lord, page 19, my lord, running page 19, my lord.
Manor, please understand that this is a point that you have to take there. We can't intervene and stay this proceeding. We will record your contention, you make it out there.
My lord, what happened, my lord? We have made the submission that was not accepted. Charge also framed. Now evidence is started, my lord.
Correct. Now this
without
is
any jurisdiction, my lord.
that we don't.
My lord, this court, my lord, a similar matter quashed, my lord. I will produce the copy, my lord.
No,
Same
maybe,
case, my lord.
maybe.
Same case, my lord. This
We are not going to enter into 1 kilometer and 13 kilometers.
My lord, in the same
It's not like
situation, my lord.
it's not like 480.
Rightly or wrongly, Tahsildar has placed some report which shows that 1 kilometer distance.
In the
Now
same,
you have to revert that evidence by placing some document.
Just cognizance taken. Trial ಆಗುತ್ತೆ. Trial ಅಲ್ಲಿ ಹೇಳಿ.
Petition and pursue your remedy before the authority.
Yes.
my lord, may I request, my lord, kindly see, my lord, page number 28, my lord. My lord, one point, my lord. Page 28, my lord. Serial number 19 is the Tikota, my lord. From 19 to 25, there is a more than 13 kilometer. Information is given by the third respondent, my lord. Act says only 3 kilometers. The respondent himself give the information that it is a 13 kilometers. When the same person given the information that it is more than 13 kilometers, when Act says it is
Then report is wrong.
my lord, my
Report is wrong.
yes, my lord.
That we can't determine.
No,
That has to be
my request is, my lord, in the similar circumstances, what happened, my lord, this honorable quashed the proceedings because there is no jurisdiction, my lord.
Order ಬೇಕಿದ್ರೆ order ಬರಿತೀವಿ ಇಲ್ಲ withdraw ಮಾಡ್ಕೊಳ್ಳಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಬಹುದು ಯಾವ್ದು ಬೇಕು ಹೇಳಿ.
Not pass out, my lord, my lord. I will get the judgment. Otherwise, my lord, directly responding, what is the there, some get instructions, my lord, otherwise.
No, no, no.
ಅವ್ರಿಗೆಲ್ಲ ಅಲ್ಲ ಅವ್ರು ಹೇಳಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಂಡು ಏನ್ ವೆದರ್ ಅಪ್ಲೈಸ್ ಆರ್ ನಾಟ್ ಅಂತ ಕ್ಲೋಸ್ ಇಲ್ಲೇ ಮಾಡ್ಬೋದು ಮಿ ಲಾರ್ಡ್. Get kindly pass on, I will just kindly pass on.
Pass over for what?
I will get the judgment, my lord.
No, no, we are not going to
ಇಲ್ಲ.
follow any judgment. We are not going to follow any judgment.
My lord,
These are all
maybe
factual
Monday,
matters.
I will do some
No,
instructions.
nothing.
My lord,
No adjournment. No adjournment.
please, my lord, it may be taken on Monday, my lord. Otherwise,
no.
pass on, my lord, at least 2:30, my lord, it may be passed, 2:30.
ಇನ್ನು ಲಿಸ್ಟ್ ಬಂದಿಲ್ಲ.
My lord, at least ಅವ್ರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಆದ್ರೂ ತಗೊಂಡು ಕ್ಲೋಸ್ ಮಾಡ್ಬೋದು ಅಂತ.
Tolu similar.
Yes, next. Yes.
Number 30, Deepak V. Bharat.
Madam.
My lord, a week's accommodation may be granted in serial number 13.
Request week's time granted to do the needful. Next.
Serial number 14, Ratnayan Shivayogi Math.
This matter, my lord, insofar as respondent number 3 is concerned, my lord, now, my lord, she has been kept under suspension. And I have been, my lord, promoted and transferred to that place. That is the only place, my lord, in Karnataka region, my lord, where, my lord, the local candidate can be accommodated. Now, my lord, they need to.
I'm filing the memo along with the report as per the directions of this honorable court. Both were present before the, my lord, director, and that is the order.
ಸಾಲ್ವ್ ಮಾಡಿದ್ದೀರಾ?
ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ?
Strong thingly only says ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ನಾವೇನ್ ಮಾಡಕ್ಕೆ. So what happened? Just tell us what happened.
My lord, here, my lord, your lordship earlier directed me to take the instruction whether the lower cadre officer can post at the higher post, my lord. In the meantime, that officer was, my lord, suspended, and that was fall vacant. And when this matter is pending, my lord, and the transfer was made, my lord, now the Mahesh Patel appearing, that person was posted to that post after the suspension. Therefore, your lordship, on the last occasion, I was not present as per the instruction, my lord. Your lordship directed by calling both the officers and solve the, my lord, issue. And they were present, they have gone, my lord, and the meeting was held. And after the meeting, this is the proceedings which was taken place, that was narrated, my lord. ಯಾರು ಎಲ್ಲಿಗೆ ಏನು ಅಂತ ಹೇಳಿಲ್ಲ, ಇದು ತಮ್ಮ ಗಮನಕ್ಕೆ ತರಲಾಗಿದೆ ಅಂತ ಹೇಳಿದೆ.
I'm sorry, my lord, there is some inconvenience, my lord.
Page number 3 is the, my lord, relevant. Page number 3.
Yes.
ದಿನಾಂಕ 25/6/24 ವರ್ಗಾವಣೆ ಮಾರ್ಗಸೂಚಿ ವಿವರಣೆಯಲ್ಲಿ ಕ್ರಮ ಸಂಖ್ಯೆ 3ರಲ್ಲಿ that is ಚಲನವಲನ which I have submitted on the last occasion, my lord. ಅರ್ಜಿದಾರರನ್ನು ಒಂದೇ ನಗರ ಪ್ರದೇಶದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವ ಒಂದು ಕಚೇರಿಯಿಂದ ಇನ್ನೊಂದು ಕಚೇರಿಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಲಾಗಿದ್ದು ವರ್ಗಾವಣೆ ಎಂದು ಪರಿಗಣಿಸದೆ ಚಲನವಲನ ಪರಿಗಣಿಸಬೇಕಾಗಿರುತ್ತದೆ. Thereafter, ಆದುದರ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅನಂತರದಲ್ಲಿ ಉಂಟಾಗಿರುವ ಬೆಳವಣಿಗೆಗಳನ್ನು ಗಮನಿಸಿ ಅರ್ಜಿದಾರರ ಕುಂದುಕೊರತೆ ಗ್ರೀವೆನ್ಸ್ ಕುರಿತು ವರ್ಗಾವಣೆ ಮಾರ್ಗಸೂಚಿ ಅನ್ನುವ ನಿಯಮಾನುಸಾರ ಪರಿಶೀಲಿಸಿದಲ್ಲಿ ಅರ್ಜಿದಾರನು ಒಂದೇ ನಗರ ಪ್ರದೇಶದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿರುವ ಒಂದು ಕಚೇರಿಯಿಂದ ಇನ್ನೊಂದು ಕಚೇರಿಗೆ ಸ್ಥಳ ನಿಯುಕ್ತಿಗೊಳಿಸಲಾಗಿದ್ದು ವರ್ಗಾವಣೆ ಎಂದು ಪರಿಗಣಿಸದೆ ಚಲನ ಪರಿಗಣಿಸಬೇಕಾದ. ಮುಂದುವರೆದು ಶ್ರೀಮತಿ ಸವಿತಾ ನಾಯಕ್ ಕೆಳಹಂತದ ಅಧಿಕಾರಿಯವರ ಅಮಾನತಿನಿಂದ ತೆರವಾದ ಏಕೈಕ ಹುದ್ದೆಗೆ ರಾಜ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಡಿ ದಂಡನಾವಧಿಯಿಂದ
decide whether it is a transfer or not legally.
Yes. No, my lord, what happens?
No, let us see. While noticing that the petitioner was displaced by respondent number 3, various contentions were raised by counsel for the petitioner that respondent number 3 was not competent to hold the post to which he was posted displacing the petitioner, which was impugned. In the
Please, ma'am. Please, ma'am.
in the interregnum, it appears that respondent number 3 was placed under suspension, subsequent to which the state submitted that in place of Savita, another employee has been posted and is working.
No, my lord. In place of Savita, Santosh Budige was posted.
Correct. Some other person.
Some other.
Other neighbor. Full stop. Next. In the meanwhile, as per order dated 20th February 25, the government was directed to look into whether the administrative issue that has arisen could be solved as respondent number 3, Savita, had been placed under suspension. Memo with enclosures is filed on record. Full stop. Relist the matter.
Lord, may I
Full
make one
stop.
submission?
Next. The court will now have to decide whether the order of whether the order called in question by the petitioner amounts to an order of mere chalana valana and not transfer. Said question to be remains still to be adjudicated. Relist the matter on date coding. Now, meanwhile, you give a copy of this to the petitioner.
I have served, my lord. I have served.
My lord, one more submission.
Yes, yes.
One more submission, my lord, that when the, my request is, my lord, when the matter is seized before the court, your lordship direct them to why they have posted this person. Anta. When this matter is posted for this court, for that place, my lord, they have posted some other person.
Full stop.
Except without giving any reasons, my lord.
For the submission of counsel for the petitioner is that no alteration of the original order impugned by the petitioner could have been made without permission of the court. Full stop. All contentions are kept open. Relist the matter on.
May I make one submission?
You file whatever you want to.
May be permitted.
You file it. We'll see. Serve copy. Yes, next.
Please.
Number 50, Abhishek K.
बरे चलाना वाला ना ने ट्रांसफर Dengli. Now, what we were saying, if at all that you wanted to bring clarity, saying that in the same building, from one table to the other, you could have amended the definition of transfer instead of introducing one more Kannada word for which we have to go to the dictionary and hundreds of judgments have to be passed. What I'm saying, suppose according to you, from one table to the other table in the same building or administrative office, if you wanted that not to be treated as transfer, you could have amended the definition of transfer and made it simple.
I will inform you.
Yes.
Number 50, Abhishek K.
Please, my lords. I appeal for the appellant.
Put it. Yes.
Yes. The respondent number 1, my lord, supposed to file the order copies, my lord, said that on last time, said my lords, while order dated 13/2/2025, my lord, your lordships has observed. The further pointed out the petitioner has filed various writ petitions.
No, just 1 minute. Now we have granted some interim order.
Please,
respondent number 2. Who is respondent number 2?
My lord, that is a private institution, my lord, where the petitioner was studying.
Let them also come on record. Why don't you take out hand summons?
My lords, we already, instead of hand summons, my lord, the service may be completed.
Office to put up report regarding notice issued to R2. Relist the matter on date code.
17th of March.
Interim order granted may extend. Interim order granted may not can be
extended till the next date. Yes.
Obliged.
office has raised an objection with regard to the Kannada document at Annex A, my lord.
The office objection.
Annex A, my lord.
With respect to furnishing of translated copy of Annexure A. Annexure A.
Yes.
Is kept in abeyance for the present in light of the submission made.
Annexure C has been passed by learned single judge. My lord, the petitioner is a owner of a particular plot. He has
What is the
existing.
direction?
Direction, my lord, to consider a representation for E-Asti. He has already manual khata, my lord. He had made an application for E-Asti, my lord. Till date, my lord, it has not been considered. The direction was for consider the application.
Who is the officer?
Zonal commissioner.
Issue notice to the first respondent. AG accepts notice for the second respondent. Release the matter on.
8th of March. Number 17, Ganesh Naik.
I'm appearing, my lords.
Yes, yes.
My lords, the registry has raised objection that there is no CC copy of due to some urgency, my lords, we could not provide. I undertake to furnish it at the earliest, my lords.
That is office.
As of now, it may be kept in. And there are 3 IAs, my lords. The petitioners were president and vice president of the Yellahari Gram Panchayat, my lords.
Now, what has happened now?
Now I am challenging the final order passed by the single judge, my lords. Wherein, my lords,
Page,
my lords, 10 minutes. 10 to 16, my lords.
What was the ground raised?
On the ground that, my lords, I have been served the no confidence meeting on 24 and 25, and the affidavit has been filed by the PDO, my lords, respondent number 4. Whereas I have not put any signature, date on the below the signature, my lords. And solely upon the affidavit of the PDO, my lords, the learned single judge has dismissed our petition.
Just read the single judge's order.
Yes, my lords.
Read the order.
Yes, my lords. Page 12, my lords.
Yes, yes.
The petitioners, being the Adhyaksha and Upadhyaksha of Gram Panchayat Yellahari, are before this court challenging the validity of a notice dated 24/12/2014 issued by respondent number 3 convening the meeting of the members of the Panchayat on 10/1/25 to consider a motion of no confidence. The petitioners contend that they were elected for the second term of the Panchayat on 4/2/2023 until date. They have completed 19 months from the date of their elections. They contend that certain members of the Panchayat had submitted a representation dated 21/12/2024 expressing lack of confidence in the petitioners and requested respondent number 3 to convene a meeting to consider the motion of no confidence. Accordingly, respondent number 3 issued a notice dated 24/12/24 convening a meeting on 10/1/25. Petitioners being aggrieved by the said notice are before this court. The petitioners contend that the notice of the meeting was served on 26/12/2024 and therefore there was no clear 15 days notice as mandated under Rule 3(2) of the Karnataka Panchayat Raj motion of no confidence against Adhyaksha and Upadhyaksha of Gram Panchayat Rules 1994 for short rules. The learned counsel for the petitioners reiterated the above contentions and contended that the petitioners had received the notice only on 26/12/2024 and hence the meeting is in violation of Rule 3, Sub Rule 2 of the Rules 1994. Therefore, he prays that the notice be set at naught and fresh proceedings be ordered. Per contra, learned counsel for the private respondent contend that the notice of the meeting was served on the petitioner 1 on 24/12/24 and petitioner number 2 on 25/12/24. And therefore, the petitioners were granted 15 clear days notice of meeting. Learned additional government advocate also reiterated the above contentions and contended that there was no procedural irregularity in the conduct of the meeting. This court directed the learned additional government advocate to secure the file relating to no confidence motion initiated against the petitioners. The learned additional advocate has placed on record the file which discloses that the petitioner had received the copy of the notice but had not marked the dates which while acknowledging the receipt. When this writ petition was listed on 25/1/25, the learned additional government advocate submitted that the Panchayat Development Officer has submitted a report dated 26/12/24 to respond number 3, indicating the service of the notice on the petitioners on 24/12/24 and 25/12/24 respectively. At this stage, learned counsel for the petitioner submitted that if the PDO files an affidavit admitting that she had served the notice of no confidence motion on 24/12, the petitioners would not press this petition. Accordingly, the PDO has filed an affidavit on 28/1/25 stating that the notice of the meeting was served on petitioner number 1 on 24/12/25 and on petition number 2 on 25/12/24. After hearing the learned counsel for the petitioners and learned counsel for the private respondents and learned additional government advocate, and after perusing the material on record as well as the affidavit filed by the PDO, it is evident that the meeting notice was served on petitioners on 24/12/24 and 25/12/24 respectively. Hence, the meeting held on 21/25 was well beyond 15 days period, thereby giving 15 clear days notice to the petitioners. Hence, there is no procedural irregularity in the proceedings held by the respondent number 2 to convene a meeting to consider the question of no confidence warranting interference. Hence, the writ petition lacks merit and is dismissed.
No, now you have not put the date while taking the notice.
Yes, my lord.
So that
I have signed it on 26th, my lord.
we don't know. We don't know because
I have contended it on affidavit and petition itself, my lord.
but they also filed an affidavit. PDO stated that petitioner number 2 on 25th, petitioner number 1 on 24th. So minus both of them have taken divergent stands. Now how we can enter into in this proceeding? And finally, you are the person who sought to be displaced. So now you can't take any benefit from the non-writing of the date.
For filing, for the purpose of filing, it appears manner they have signed 26ನೇ ತಾರೀಕು ಸ್ವೀಕರಿಸಲಾಗಿದೆ ಅಂತ ಅವ್ರು ಬರೆದು ಸಹಿ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೋಸ್ಕರನೇ ಅಫಿಡವಿಟ್ ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ದು.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಬ್ಲಾಂಕ್ ಇದೆಯಲ್ಲ?
ಬ್ಲಾಂಕ್ ಇದೆ.
But so we don't know when.
Yes, my lord. For that purpose only, my lord, PDO was asked to file the affidavit. If 25 is taken, December is 31. ಹಾಗಾಗಿ it is there is a clear 15 days.
My lords, kindly peruse page number 40, my lords. It is the first report submitted to the Assistant Commissioner, respondent number 3, my lords, wherein it is only the PDO submits that they have received the notice. He improvises on page 37 at later notice, my lords.
No, correct, but now it's your word against his word. He's an official. He's working on the behest of the Assistant Commissioner. Why should we disbelieve the PDO and believe you? You have all interest in having it deferred.
I may be permitted to read the page 40, my lords.
My brother says that prima facie there's nothing.
My lords, I may be permitted to read page 40, my lords.
Yes.
This is the report submitted by the PDO to the Assistant Commissioner. ಗೆ ಮಾನ್ಯ ಸಹಾಯಕರು ಆಯುಕ್ತರು ಯಾದಗಿರಿ 26/12/2024 ಮಾನ್ಯರೇ ವಿಷಯ ಗುರುಮಿಟ್ಕಲ್ ತಾಲೂಕಿನ ಯಲೇರಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರು ಬಟ ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಮಂಡನೆ ಸೂಚನೆ ನಮೂನೆಯ ನೋಟಿಸ್ ಸ್ವೀಕೃತಿ ಪತ್ರ ಸಲ್ಲಿಸಿರುವ ಕುರಿತು ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಲೇರಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರು ಬಟ ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಮಂಡನೆ ಸೂಚನೆ ನಮೂನೆ 2ರ ನೋಟಿಸ್ ಸ್ವೀಕೃತಿ ಪತ್ರಗಳನ್ನು ದೃಢೀಕರಿಸಿ ಸಲ್ಲಿಸಿರುತ್ತವೆ. ಸ್ವೀಕೃತಿಗಾಗಿ ಮಾನ್ಯರಲ್ಲಿ ಹಿಯರ್ he doesn't mentions any date on which I have been served. Petitioners have, appellants have been served. Later on, my lords, when the writ petition has been filed at page 37, my lords, original and typed copy at 38, my lords, wherein he improvises his case, my lords, PDO, my lords.
Yes.
ಗೆ ಮಾನ್ಯರು ಮಾನ್ಯ ಸಹಾಯಕ ಆಯುಕ್ತರು ಯಾದಗಿರಿ ಮಾನ್ಯರೇ ವಿಷಯ ಗುರುಮಿಟ್ಕಲ್ ತಾಲೂಕಿನ ಯಲೇರಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರು ಬಟ ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಮಂಡನ ಸೂಚನಾ ನೋಟಿಸ್ ಸ್ವೀಕೃತಿ ಪತ್ರ ಸಲ್ಲಿಸುವ ಕುರಿತು ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಯಲೇರಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರು ಬಟ ಉಪಾಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ಮಂಡನೆ ನೋಟಿಸ್ ಸ್ವೀಕೃತಿ ಪತ್ರವನ್ನು ದಿನಾಂಕ 26/12/24 ತಮ್ಮ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಿರುತ್ತೇವೆ. ಆದರೆ ಅದರಲ್ಲಿ ತಾವು ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷರ ಮತ್ತು ಸದಸ್ಯರುಗಳ ನೋಟಿಸ್ ಪತ್ರ ಕೊಟ್ಟ ದಿನಾಂಕ ಬರೆದಿರುವುದಿಲ್ಲ. ಆದ ಕಾರಣ ಈ ದಿನಾಂಕ 15/1ರಂದು
But this clarification was given during the pendency of the proceeding.
Yes, it did petition.
Because that question arose.
Yes.
Yes, we consider the petition, the petitioners before the learned single judge. Now you are the Adhyaksha and Upadhyaksha who have been
Removed from the office.
Already removed.
And the election is due on, my lords.
Tomorrow
that's
itself election is.
Tomorrow itself, my lords.
Tomorrow.
28th, my lords.
now you are disqualified. Illa,
Illa, Swami, I am continuing as a member.
Passed. Out of 13
Correct, correct.
members,
No,
9
now-
members have given no.
Correct, correct. He can again contest. Isn't it?
Yes, that is open to you.
When other contentions were also not considered, my lords.
ಏನ್ ಹೇಳಿ ಏನ್
Other contentions like, my lords,
ಅಲ್ಲ ರೆಡಿ ಆಗ್ಬಿಡ್ರಿ ನಾಳೆ ಎಲೆಕ್ಷನ್.
which were content.
What other contention?
My lords, page 8, my lords.
Page
Page 8, my lords. Para 16, my lords. The ground. Then, my lord.
para 16.
Para 16. my lord.
Ah,
It is submitted that the learned single judge has not considered that as annexure A1 that the notice under form number 2 as provided under rule 3(2) of Karnataka Panchayat Raj motion rules 1994. The third respondent has issued a notice on 24/12 and the meeting is fixed on 10/1/25. There is no clear 15 days notice to which the member is, which is mandatory. The mandatory nature of the provision of the rules, there may be a deficiency of 1 day and therefore this court is required to consider as to whether there is a 15 clear days notice as provided under
but
rule.
here
This
just
was
one-
considered by taking the affidavit, calling the PDO, taking, that is the
Correct,
answer to this.
Now,
para.
para 16 refers to by registered post, but PDO has said they have.
Yes, sir. On 25th and he submitted to the AC on 26th.
Yes. Petitioners, the Adhyaksha, former Adhyaksha of the Yelhari Gram Panchayat, as well as the Upadhyaksha of the Yelhari Gram Panchayat have called in question correctness of order of the learned single judge, whereby their petition came to be rejected. Writ petition was filed by the Adhyaksha and Upadhyaksha, calling in question correctness of the notice issued by the Assistant Commissioner fixing a date for considering the motion of no confidence. The petitioners had challenged the same before the single judge, asserting that there was no 15 clear days notice. The said aspect was considered by the learned single judge and a detailed order has been passed. Full stop. The learned single judge has, during the pendency of proceedings, directed the government advocate to secure the file relating to no confidence motion proceedings. And upon perusal of the same, it is noticed that the petitioners had received copy of the notice but had not marked the dates while acknowledging the receipt of such notice. Subsequently, the Panchayat Development Officer had submitted a report taking the stand that the service of notice was completed on the petitioners on 24/12/2024 and 25/12/2024 respectively. Full stop. Further, the PDO was directed to file an affidavit, which was done, stating that the notice of the meeting convened to consider motion of no confidence was served on the petitioner on 24/12/2025 and petitioner number 2 on 25/12/2024. Full stop. Upon taking note of the same, the learned single judge has dismissed the petition. The observations made at para 7 and 8 by the learned single judge are extracted below. Next. In the present proceedings, learned counsel appearing for the petitioner submits that merely taking the date of service of notice on the date when notice is dispatched would not be sufficient, comma. Further, it is contended that the Panchayat Development Officer at the first instance had furnished a report dated 26/12/2024 enclosing the certificate for having served notice. Full stop. However, it is submitted that the said receipts did not have dates on which notices were received, and it is only subsequently in the report of 15/1/2025 that the dates of receipt of notices by petitioner number 1 and 2 were provided for as 24/12/2024 and 25/12/2024. Full stop. It is submitted that though the petitioners had received the notice, according to the petitioners, notice was received only on 26th. According to him on 26th.
According to him, 26.
Full stop. However, AGA submits, on the other hand, that in light of ambiguity, affidavit has been filed by the PDO in terms of the report of the PDO dated 15/1/2025, and the same must be taken to be the date of service, as the PDO is a official of
Gram Panchayat.
of the Gram Panchayat. Full stop. Next, after having heard both sides, must be noticed that the sole primary contention is regarding 15 days clear notice. Admittedly, the meeting was fixed on 10th of January 25. Full stop. The fact regarding service of notice is not disputed. Tengli.
Yes.
Fact regarding service of notice is not disputed.
Yes.
What was disputed was only the date of service of notice. PDO has filed an affidavit that petitioner number 1 has received notice on 24/1/2025 and petitioner number 2 on 25/1/2025.
Tolu, my lord. 24 Tolu and 25 Tolu.
24/12 and 25/12.
Please.
The said submission, the said assertion backed by affidavit of an official of Gram Panchayat must be taken when the petitioners, though admitting to have taken notice, have failed to mention the date of receipt of notice. Full stop. The ambiguity in not affixing the date of receipt of notice cannot be taken advantage of by the petitioners themselves. Accordingly, taking note of the observations of the single judge at para 7 and 8 extracted above, we find no reasons to interfere with such reasoning, and the factual assertions made cannot be inquired into while the court is constrained to accept the say of the PDO upon affidavit. Accordingly, appeal is dismissed.
Please.
When
I take notice for one.
302 ne barta note.
I take notice for 1, 2, 3. Respond for 1, 2, 3.
AG accepts notice for respondent 1 to 3. Yes.
Bill number 18, Kulappa Heru.
I am for
Yes.
appellant plot. I appear
Yes.
for the respondent. It is
a case of impersonation.
My lord, they have served the additional document just
Lord
now.
will see.
Additional document has been served just now, my lord. It may be taken up next week.
Lord, there is an apprehension of interim payment of